So we have here with us today Eric Gillespie and Murray Klippenstein, who have, as of Friday, filed a class action. And so they're going to give you a 15-minute presentation about their class action and the class action process, how that applies to all of you. And then we'll have a 15-minute Q&A. We just forgot to mention ahead of time that Sandra, the counselor who had spoken at the beginning, is actually offering free counseling sessions to people who were affected by the G20. So if that's something that might interest you, there's her contact information at the back, which is a really great resource. And so without further ado, we're going to get started.
Good afternoon, folks. My name is Murray Klippenstein. With me is Eric Gillespie. And just joining us, I'd like to introduce Ms. Sherry Good, plaintiff in the class action. We'll ask her to just say a few words to you in a few minutes. Eric and I and Sherry are humbled to be here today because we know what many of you went through, and we hope that what we're trying to do will help make right a little bit what you went through, but perhaps just as importantly, we feel that what happened hurt Canadian society broadly, and we want to do something about that. As many of you know, we held a press conference at Queen's Park on Friday. You may have seen some of the coverage. I happened to see some of the reports on the TV, and it struck me that this was a very good thing in one way, at least. For weeks, we've seen again and again on TV and broadcast to millions of Canadians pictures of burning cars and a few smashed windows. I noticed when they were reporting on Sherry's class action, which may well involve some of you in the end, the coverage changed and was about people being arrested. And I thought that was a good change in the conversation to have. So that's a step in the right direction, I think. Forgive my appearance. I've had to make a choice between a jacket and tie and bicycle, and the bike won, so that if I don't look like a lawyer today, I'm a bicyclist. You look great, she says. Thank you. Yes, sorry. The class action is a lawsuit that has now been filed in court against the Toronto Police and the RCMP. The lawsuit is intended to cover those officers from those forces, but also officers from many other areas that were in Toronto. And there's legalities involved in that, but we think we have that covered. We are not suing the province or the OPP yet, because it seems that those defendants we have named cover the type of claim that we are focusing on. Eric is an experienced class action lawyer. He does much progressive court work, but for about 9 years he's been pursuing a class action against Inco for pollution, and just a few weeks ago was successful at a trial and received a judgment for the class of, I think, something like $36 million, which is the largest environmental class action so far. I have had the benefit of some litigation and public inquiry work in relation to police as one of the lawyers representing the Dudley George estate and the Dudley George family, along with Vilco in the back. And so we hope to use some of that experience in this situation as well. A class action is based on the idea of a class. In other words, you define a group of people or situations, and Eric will explain this in more detail. What we decided that it made sense to focus on for a class action is the folks who were wrongfully arrested or detained and never charged. There are some legal reasons why that makes sense. We think that covers perhaps 800 people, give or take. That may include some or many of you. some of you who were either arrested and taken to the detention center or kettled at Queen and Spadina and various other locations, and Eric will go into that. What that doesn't include is, for example, folks who were searched, probably illegally, and Eric can discuss why that, where there was some logic in that exclusion, and folks who were arrested and charged with significant criminal code offenses, and because of the way class actions work, that also we decided would not be included in this class action. Eric will give some, and we didn't do that lightly. We take very seriously what everybody went through. We had many discussions with folks who'd gone through many experiences and read a lot of your stories. And it was heartbreaking for us in a lot of ways. And but Eric can explain why. Well, I guess you can't do everything all the time, all at once. And so this is hopefully a significant piece of the overall puzzle. We said at the press conference that we thought an overall public judicial inquiry, a full judicial inquiry, was the right answer. Many of the processes that are already in place are quite limited in their mandate and their power. The same is true for a class action, except a class action has some advantages, some power that many of the other procedures don't. You can summons a wide variety of witnesses. I remember as we were coming up to the trial in the Ipperwash case, which we eventually were able to set aside for a public inquiry, which was the right thing. We sent out summonses to over 100 people in the province, all over cabinet ministers, police officers, senior, lots of people got summoned. So you have a degree of power in the court system, both to summons witnesses and to summons documents that actually give you a lot of power if you can get through all the procedural hurdles. The legal boxes or categories that we'll be relying on are what's called false imprisonment, which is a bit of a technical legal term, which means your freedom was constrained at a given point without appropriate legal justification. We think that applies to the people who were kettled at Queen and Spadina. We've included a number of subclasses, including Queen's Park, Parkdale, Novotel, and Eric can go into those a bit. There are many ways to be falsely imprisoned. If you were thrown into the detention center without legal justification, that qualifies. Various ways of that same thing happening. That's illegal, and you can sue for having your freedom infringed, and that's what we're doing. In addition to that false imprisonment idea, as you know, you, in theory, have some charter rights, and it looks like a number of those were violated, and you can claim damages in the way of money for that as well. So the lawsuit does claim damages for that. On the topic of money, every single journalist's headlines had the figure of $45 million in it. Let me tell you, this is not about money. If you're here for money, forget it. There ain't going to be any money in it for anybody. Now, having said that, for all I know, we might win and we might get some money. That is not the point. For myself, as our law firm, the only rational assumption for our firm is that we're not going to, on a planning basis, is that we're not going to make any money from this, and it's going to be a net monetary drag. Now, we're going to fight hard, and who knows, things may well go well, but I want to make that clear. I think Eric's going to talk about what you can do, how you can think about how you might fit in. So I will turn it over to Eric, but perhaps we can ask Sherry just to stand and say a very few words. This isn't intended for us to ask questions about her story, but I do want to thank Sherry. She's made a tremendous personal commitment. She was kettled at Queen and Spadina. She went through quite a soul searching to decide that she would step forward and deal with the consequences and the timelines and the burden of this. The way the class action system works is she is, in a way, a spokesman for perhaps you in the court system, although you may eventually have your say. But thank you very much, Sherry. Maybe you could say hi to folks.
Hi. I just want to say thank you for all the support I'm getting. It's really appreciated, and please keep it up because I need to see that sort of stuff. I see a lot of negative comments too, so I need to see the positive. And really, that's all I want to say is thank you. It's a privilege to be able to do this for people, and let's all keep our fingers crossed that everything works out.
Hi, Sherry.